Appeals is now in session.
Whoa. Judge Clement lowered my chair again. Okay. Good afternoon. Glad to have you. We'll be calling the cases in the order in which they appear. We are happy to have Judge John McClarty here from Chattanooga today, visiting and taking some of our cases. Yay. As you know, the Court of Appeals is all one court. We're elected statewide, so we show up in different places sometimes, and we're happy to have Judge McClarty here today. Any announcements? Seeing none, would you please call the first case?
Joey Sampson versus Aircraft Maintenance Incorporated et al. You may start when ready.
May it please the court. By introduction, I have been counsel in this case for 14 years. This matter that's now before you is the final destination of a flight that took off 14 years ago. I don't mean that necessarily.
You're Mr. Thomas, right?
Yes, I'm sorry, Your Honor. May I introduce myself to the court? Daniel Lynn Thomas, on behalf of Aircraft Maintenance, Inc., the only appellant, the only other party other than the appellee.
You wish to reserve any time?
I do, Your Honor. I'd like to reserve actually as much as I can.
That would be 5 minutes.
Which is, as I understand, is 5 minutes, but if I can ever get more, I'd love it.
No, that's it.
I understand. No, I don't mind taking it out of my initial period of time. Your Honor, as I was saying, this matter took off 14 years ago. It's been subjected, as you know from the record and the briefs, to a lot of delays in the flight. There have been some parts of this flight that were canceled, and it's ended up now here 14 years later. In that 14 years, we've gone through now, the Chancellor is no longer on the bench in this matter. Mr. Sampson, who is the owner of the aircraft, the Cessna that filed this matter, is now deceased. His estate was substituted in the Montgomery County Chancery Court. Unfortunately, none of the parties or the Chancellor are aware of his passing and death, which occurred prior to the submission to Chancellor. My client, the director and president of AMI, Mr. Robert Wyatt, had some physical injuries that caused some delays in this matter with a stroke at one point. The matter was tried initially, opened with a bench trial with the judge, or the Chancellor. It was continued on that date after the court, out of order, and all parties agreed to hear the expert witnesses, and they were qualified. They were never challenged. Another party was Cameron Development. Cameron Development determined not to take an appeal. In addition, Mr. Wyatt individually, who was sued by Mr. Sampson, also elected not to take appeal. The issues that are not before the court appeal are probably the law of the case. In this matter, other than what we've raised on appeal, there is no cross.
Counsel, this has certainly been an odyssey with this case. I want to make sure that I have a clear understanding of what evidence was presented to the judge.
More than fair, Your Honor.
So we have, in 2016, we have Kent Thomas, Stephen Wilson, Robert Yorick, all testify in person in front of the chancellor. Right so far? Or?
You're 100% correct.
Okay, in 2020, October and November of 2020, we have a disagreement about whether or not Mr. Sampson's prior deposition should be admitted or not, whether he should have to testify or not. But there's additional testimony that wasn't in person in front of the chancellor, if I'm understanding it correctly, from Robert Wyatt, Pierre Barrero,
I believe that's correct, Your Honor.
Roger Lee Miller, and John Patterson. And then there's deposition testimony, and let me make sure I've got this right. Joey Sampson, Bill Cruz, Robert Wyatt, and Jose Ortiz. So deposition testimony before the chancellor from those four. Is there any other deposition testimony?
No, Your Honor, there's not. And in fact, with that point, one of the issues that the chancellor ruled on, he would take and rule on all the evidentiary challenges that were filed in 2016 to the depositions, which both sides briefed for him as far as the rules of evidence, and that was never ruled on.
In terms of the depositions, where in it, I had some struggles in terms of finding them in the record. Where in the record would I find the depositions in this case of Sampson, Cruz, Wyatt, and Ortiz, especially Sampson? I found some excerpts along the way. Can you point me to anywhere in the record where I'm going to see Joey Sampson's deposition?
Your Honor, it was my belief that they were a part of the record that came up here from the Chancery Court clerk. In fact, when I reviewed the record in Clarksville back in November, they were there. Okay. Now, I didn't check the record once it came, 50 miles down 24, but they should be in there. I might add, as far as that deposition was taken very early in the case before the pleadings were amended. And Mr. Sampson had to be ordered by the chancellor to come to Montgomery County. He lived in Georgia. And that was it. I tried for, I can't tell you how many years, to be able to get even his discovery deposition based on all the facts that we were learning as this thing went along and as the complaint was being amended and the counterclaims. Never got that far. He was always an unavailable witness by, and you'll find this in the record, by one-page excerpts from a doctor that he couldn't sit through a deposition or do anything. The chancellor had the same type of objection to the first discovery deposition. Tried like heck. In fact, you're going to find in the record, we renewed our motion objecting that he was unavailable in 2019. We attached the affidavit of an individual who went down and participated with Mr. Sampson in his hometown in Georgia. And we asked for commissions to go down there. We never got anywhere. We never had the ability to cross-examine Mr. Sampson. In fact, I would tell you, Your Honor, the chancellor never saw Mr. Sampson in person. He did see Mr. Wyatt through some various hearings that we had there in the Chancery Court, but that occasion never occurred.
What's this court's standard of review in reviewing a factual determination that's made based upon deposition testimony?
I think you're de novo. I think we both agree that this matter is de novo. I think you're in a position that, fortunately or unfortunately, that basically it's a reboot. No jury trial, no ability to observe the witnesses necessarily, other than the two, like as you've just pointed out, the two experts, and Mr. Kent Thomas, who's no longer in this matter, and the other witness who testified on that date. That's it.
Is there any evidence in the record other than Sampson's statement that his original understanding was that he was going to get these repairs that were going to make the plane airworthy, that would suggest, I guess what I'm looking at is Cruz's testimony in the record supportive of Sampson's assertion that he was going to get an airworthy plane back?
My best recollection, Your Honor, and I don't want to mislead this court in the slightest, is that Mr. Sampson communicated at a later time with Mr. Cruz. He came on. I believe Mr. Cruz related some hearsay, but you've got actually Mr. Kent Thomas's testimony both live, and Mr. Sampson's then attorney, Mr. Morrow, deposed Mr. Kent Thomas down in Destin, Florida. One of the major issues that you've just hit on is the definitional standard of airworthy versus an annual inspection. And that was testified to, I think, in great detail by both of the experts who both looked at the airplane, talked to the mechanic who was an employee of AMI, and looked at all the logs, and actually taught, both of them taught courses for instruction with the FAA standards, and both of them went to great detail and also the standard of the industry. Mr. Sampson, interestingly enough, had owned an aircraft for a long time. He was no longer qualified medically to fly. The plane was not by the log standards of the FAA, was not allowed to be flown because it had been on an annual.
Were the airworthiness repairs here, and I'm thinking of the squawk list
Sure.
at this point, were the squawk list airworthiness repairs completed after the transaction with Cameron had fallen through, after Cameron had already said, no, I'm not going to purchase the plane through Mr. Thomas?
You have three different contracts, in my view. The first one for the annual, Mr. Thomas's company paid for that. Second agreement, Mr. Sampson contacted AMI and wanted a nose gear replacement done, which was on that squawk sheet, the very one you're referring to, which had 70 some odd items. That the aircraft mechanic was the one who put that together. And then you get to the final one. Okay, now that work is after Mr. Kent Thomas, he informs, and Mr. Sampson is aware that he's not going to buy it. They differed over $4,000. Mr. Sampson then authorizes the second agreement, which is to do the nose gear repair, which eventually we get paid for after the mechanics lien. And you get the third one, which is the 28 items that were culled down from the squawk list of 70 some odd items that went back and forth. So you've got three separate, really, if you think about them, agreements. And I think I'm about to run out of time.
You have you finished? Did you finish anything?
Well, if I've answered.
Do you need to? Okay. Well, we'll see you in a few minutes.
Thank you, Your Honor.
Good afternoon. I'm Roger Manus from Clarksville. I represent the executor for the estate of Joey Sampson in this matter. And preliminarily today, I'd like to, if I may, introduce my associates and colleagues in the front row, Colleen Hyder and my son Austin Manus, who both of whom work as lawyers in my office. So it's their first trip down to the Court of Appeals. So my son had worked on the case and he was familiar with it, and Ms. Hyder had not been here before. So,
well, the pressure's on you then.
Well, as Your Honor knows, I've been here a few times in the past. So Ms. Hyder and I were talking about it on the way down here today about how sometimes things congeal in your mind at a certain point, and it occurred to me during that conversation that this case really congealed in my mind in the trial, the abbreviated trial in 2016. Now, neither Mr. White was in the hospital at that time with a stroke, and my client was excused from coming. He had been in infirm health for many years prior to his demise earlier this year, and then of course COVID hit, and he really did not want to travel to Tennessee from South Georgia once that happened. So, but we had this abbreviated trial, and Mr. Kent Thomas of Cameron Development, which was then a defendant in the case, testified live from the witness stand. And counsel for AMI, adverse counsel, introduced a number of exhibits that day. And among the exhibits that were introduced that congealed this case in my mind were an offer and a counteroffer by Mr. Thomas and Mr. Sampson. Now, keep in mind that this airplane, Mr. White goes down to Georgia, picks up this airplane in October of 2007. There's a lot of dispute about what Mr. White told Mr. Sampson, what Mr. Sampson told Mr. White, but I don't think there's any dispute that Mr. Sampson was selling the plane in an as-is condition. And here's why I say that. He brings the plane back to Clarksville Outlaw Airfield. Not a lick of work is done on that plane for the next 2 or 3 months. But 1 month later, in November of 2007, Mr. Cameron, not having seen the plane, offers $112,950 for the plane, and my client then, he wasn't my client at that time, he was represented by another fella, but Mr. Sampson counters at that time with $116,000.
Counsel, had the annual inspection already been done at that point?
No inspection had been done until January. And that's not my witness, that's that's the other side's witness. Roger Miller, the aircraft airworthiness inspector, they call him an AI, didn't do the inspection until sometime in mid to late January. And at that time, he worked up what he calls the squawk sheet, which is a list of things that either need to be done or have to be done in order to make the plane airworthy. That did not occur. The inspection itself didn't occur until January. But these offers were exchanged in November for the plane that had not been either inspected or worked on at all and was being sold in an as-is condition. That puts these parties $3,050 apart on an as-is transaction in November of 2007. So Mr. White would have us believe that a couple of months later, after this deal had not come to fruition, and Mr. White admits that it's his testimony that my client, Mr. Sampson, began to call after November, after it seemed like they were $3,000 apart and we weren't going to get together. Mr. Sampson began to call and had Mr. Cruz call from South Carolina saying, when are we going to get the airplane back? When are we going to get the airplane back? And that continued right on up into January. So it was not until January that this inspection occurs. And the inspection works up a squawk sheet of all these things that need to be done, which included, but was not limited to, the repairs to the nose gear.
Counsel, I want to ask about those repairs to the nose. So my understanding is Mr. Sampson is saying that he thought he was going to get back the plane in an airworthy condition at no cost to him. Why is he then spending more than $3,000 of his own money on the repair to the nose if he thinks he's getting back the plane at no cost? I'm having a hard time reconciling those two things.
Well, because I don't know the answer for sure because I wasn't there at the time, but it seems to me that the nose repair was something that had to occur in order to fly the plane with the nose gear retracted. It was shuttled up with the nose gear fixed from Georgia with rebar holding it in place and all the gear down, which makes the plane very unwieldy in the air.
The repairs that were done in this case, though, the $18,000 plus in repairs that were done that are being fought over here, these were all related to airworthiness, though, weren't they? I mean, these aren't aesthetic repairs that are just for, well, the plane will look sharper. It's instead all of these were related to making the plane airworthy, weren't they?
I'm not sure. The truthful answer to that question is I'm not sure about that. I can't say in regard to that.
Did Mr. Miller indicate in his testimony that they were all related to
I don't remember, to be honest with you on that. I just don't remember on that. But I will tell you that an interesting thing that developed from Mr. Miller's testimony, it's a nuance, but it's a very important nuance, was that all of these things are listed on this squawk sheet. And he went in and started doing this work, I think, in February or sometime from maybe after late January, and didn't complete it until May. And he didn't write on the squawk sheet. He made notes as he went along, but he didn't write on the squawk sheet, "I finished the nose gear." Right? He just wrote on there the whole thing. So when it came time to prepare an invoice, if in fact Mr. Sampson had back in January authorized a repair of the nose gear, and a few days later authorized a repair to the rest of the repairs, the nearly $19,000 worth of repairs, then why was it necessary to send 2 invoices in that situation? And the answer is it wasn't necessary, because at that point Mr. White had authority to not only do the nose gear and the other $19,000 worth of work. It wasn't going to be invoiced until May. The work was going to be done over a period of 2 or 3 months with no indication on the squawk sheet as to what happened when. Then why not just send one invoice?
Yeah, so I'm struggling a little bit on what's in it for Wyatt here. Wyatt goes down to Georgia and ends up having a conversation, and Sampson says, he told me that I was going to get back an airworthy plane. And experts tell us that it would be fairly typical, right, for somebody to do the annual inspection, but the inspection's different than repair for airworthiness. I'm struggling to see why Wyatt wants, or why AMI wants to repair a plane that they know is in some pretty rough condition for free.
Well, it's not for free. It's to impose a lien on it and retain it. And look at, now we are, 14, 15 years later, and the plane sits tied down to a tarmac in Clarksville, virtually worthless. And that's the answer to the question. He was successful in retaining possession of that plane for them these years, in hopes of eventually winding up with the plane, claiming not only repair costs, but also storage costs for this plane that he had no authority to repair.
Are there any factual findings from the chancellor that suggest this is some kind of, and that AMI set out to do that, to essentially pull the wool over the eyes of Mr. Sampson in this case?
Well, the factual findings from the chancellor are that Mr. White went down to Georgia and made certain representations to Mr. Sampson because there was no other reason for Sampson to release the plane to White on it.
Isn't
the
he
plane
getting
had 2 new engines.
a free annual inspection and potentially $100,000 plus purchase on a plane that's just been sitting there degrading?
Well, precisely. That's precisely. You get a free annual inspection, and or you get the plane sold. One or the other.
But isn't there a difference between the annual inspection and the airworthiness repair?
I think there is probably a difference in respect to that. And that's why what happened in January is important. In January, when after Mr. Sampson had called upon Mr. White to return the plane beginning in November right up to January, they had a discussion about it. There's no dispute about that. That a discussion was had about these repairs. That both Mr. White and Mr. Sampson agree that a discussion was had about that, and a cost quote was given. Mr. Sampson says he didn't authorize it, and Mr. White says he did on it.
Hey, Counsel, a question I asked to opposing counsel with regard to, I struggled to find the depositions in the record. Maybe I'm just missing them. It's a voluminous record. Can you point me anywhere in the record where I can find the depositions in this case? And depositions certainly seem like absolutely critical testimony in this case, given how it was heard by the judge.
Outside of my statement of the facts, I cannot on that. I heard Your Honor's question to counsel, and frankly, I was not prepared to answer that question today. So I don't know the answer to that question in regard. But I do believe and have thought through this. I struggle with this case because I like to get them ready and try them because they don't get any better with age, as a general rule. And so I struggled with this case as he got older. Mr. Sampson was sick all the time. Every time I tried to get it set for trial, somebody would be sick, Mr. Wyatt or Mr. Sampson. So we finally get to a point where I'm ready to get it concluded one way or the other. And I know Mr. Sampson is not going to want to come up here. And so I'm looking at how I'm going to prove this case using the testimony of that's either already been given in the form of Mr. Thomas and those offers and Mr. Wyatt's own testimony and those of his parties. And so that's primarily, if you look at my statement of facts in the brief, primarily what I've tried to do. I did make a reference or two to Sampson's testimony, but most of the things that Sampson has testified to that are in some way different from what Wyatt says are fairly nuanced. But Wyatt says that he received out of thin air the logbooks one day. But he admits that when he went down the second time to get the plane, that they stopped off in Columbus, Georgia, to get some papers. Well, there wouldn't be any reason to stop. What Sampson said was, we stopped and I gave him the logbooks. Wyatt admits they stopped. Why else would they have stopped? To get the logbooks is the answer. That's a factual dispute, for example, between the two of them. But there's just, other than that, there are very few factual disputes. One critical factual dispute is the issue of whether the repairs were authorized or not.
And that's just a he said kind of thing, isn't it?
It is. It is.
No other proof from anyone else other than the two principals as to whether that was authorized or not.
That's right. That's right. And I'm struggling with why my client would authorize $19,000 worth of repairs to a plane that he was only $3,000 apart from selling a couple of months earlier on an as-is basis. Now, why would he do that? I just can't imagine under that scenario. The only reason that I can surmise that he would do that under that scenario, and that again requires some imputation of dishonor to him that there's no indication of in the record, would be that he authorized it not intending to pay for it. That he in fact authorized it, didn't intend to pay for it, and thought he would just.
Counsel, isn't this one of the problems with the inability to cross-examine in this case in 2020? Because part of what I think opposing counsel might suggest is, well, in fact, Mr. Sampson had a long history of not paying people for repairs on, or prior history, maybe I shouldn't say a long history, but a prior history of not making payments with regard to other transactions on repairs on his plane.
I'm only aware of one situation involving that resulted in a lawsuit. And I could make that argument clearly about Mr. Wyatt doing unauthorized work, because there's a reported case out of this court which found that he did work on a plane that was unauthorized. It's in 102 Southwest 3rd, the Klosterman case. So I'm out of time. Well, looks like I'm not out of time.
You're not quite out of time.
The yellow light's up.
You're close.
So, yeah, I'm getting close, but anyway. So there is a history. There is a history, for sure, of unauthorized work being done by Mr. Wyatt in a similar case to this. Not identical, but
Counsel,
similar.
do you agree that the standard is, given the fact this is from depositions, that the standard here is de novo in terms of this court's review?
I do agree it's de novo, and I do agree that in the absence of the ability to, because it's on a written record as opposed to an in-court testimony, that there's no presumption of credibility determinations in regard to that, because it's a paper record essentially before the trial court as well as before this court. So,
thank you, Mr. Menez.
It please the court again. Addressing the question of dishonesty, the trial court made findings and conclusions dismissing the claims of misrepresentation, fraud that were all made against Mr. Wyatt individually. There was no lawsuit filed against Outlaw. Addressing also the length of this proceeding, I think when your honors go through the record, you'll find that as far as AMI was concerned, there were a number of motions to dismiss, motions for summary judgment on basically the issues that are now, again, on appeal. that were filed back in the early portions of this lawsuit, 2009, 10, 11, and 12. It was sold, the airplane was sold as is. Your Honor has inquired, well, and there's been discussion of why the delay. There's testimony in the record that you will find that AMI operated as first in, first out. This was not like Jiffy Lube where one came in and you were backed up. These things take time. So the delay was in actually getting it done. Now, Your Honor, you inquired about just a he said, she said. No, sir. There are emails that are in the record. There are other correspondence in the record as far as the squawk sheet with the 78 or 70 some odd, and then the 28. These costs were capped, just like the labor costs were capped at Mr. Sampson's request. Capped. Plus the actual out-of-pocket cost to AMI for parts and the taxes that it paid to the state of Tennessee for each of these transactions.
Is there an email in the record from AMI to Mr. Sampson with the list of repairs?
I believe there is, Your Honor. That's my best recollection as I stand here. I would also tell you that there was a question concerning, well, what's the delay? After the $4,000 failure to meet over this aircraft, and this aircraft, again, had not been flown in years, and this was the third mechanic that really had not been paid, and the only one he didn't end up in litigation with Mr. Sampson. Mr. Sampson then entered into some discussions to sell the aircraft to AirScan, a company out of, I believe, Kansas or somewhere out in that general area, who sold aircraft to the military, specific aircraft that were used at that point, had been used in the Iraqi war and in the East. AirScan was interested. AirScan kept calling AMI to find out when it would be done. When the record has a stipulation in it that I entered into with Mr. Morrow that didn't lose any sale to AirScan. AirScan determined once it actually got documentation, a pretty large-sized company with a governmental contract, that in fact these engines were not as represented by Mr. Sampson, it backed out. That is the exact same period of time that Mr. Sampson comes back to AMI and says, now let's talk about what I've got to do to have this thing completed. That's when, Your Honor, the 78 went from the nose gear and then went back to finishing those 28. In fact, all work was completed to make this aircraft airworthy and certified by Mr. Miller as he testified. At the very end, they test drove the aircraft, only to find out, because you couldn't, and the testimony is in the record, you couldn't determine that the fuel gauge was not working until you got up. They learned the fuel gauge didn't work. Notified Mr. Sampson. Mr. Sampson said, I'm not going to repair that fuel gauge. At this point, his contract with AirScan had been terminated by AirScan. He said, I'm not going to do it. And I said, look, all you got to do is put in this, you've got to have a fuel gauge to meet the FAA requirements. He wouldn't do it. Now, at that point, there was no longer any AirScan contract for him to complete.
Counsel, that was after, though, the other squawk sheet repair communications had already broken down between Sampson and AMI, right? I mean, AMI had already heard from Sampson at that point that he wasn't going to pay for the other repairs on the plane.
Correct. It was culled. You got inspection, annual inspection, nose gear right after that. Then he goes into, well, let's talk about culling down the 70 some odd items to 28. And Your Honor asked a question I think I'd like to address. What is required for an airworthiness? Well, first off, it's this license of the certified mechanic. He's the one signing, or she, as the case may be. For certification, now you're meeting the FAA standards. For the annual, you're also meeting, as I learned through this case, the manufacturer's requirements for an aircraft. So you got two standards. You got the FAA standards and you got the manufacturer standards. And as you asked me earlier, were some of these amenities? Yes, they were. And those are some of the manufacturer's standards, if you were to put it back. I think I've exhausted my time,
Yes, sir.
and thank you. Your
Thank
Honors.
you. Thank you both. And nice to see your guests. Would you call the next case, please?